Well, there are growing questions today about the Justice Department announcing that they are reinstating the controversial practice of asset forfeiture. Critics are concerned because they say that it allows law enforcement to seize any suspect's possessions without necessarily having to issue a criminal conviction or in some cases even an indictment. But the department is defending the move, saying that they're going to be putting in place certain safeguards to ensure that there is sufficient evidence of criminal activity and that the evidence is well documented. CBS News Justice reporter Paula Reid is in Washington. She joins us now. So break this down for us, Paula. What actually is asset forfeiture, and does it have a legal role in criminal investigations?
It does have a role in some criminal investigations. Asset forfeiture is when law enforcement seizes property, be it a house, a car, or cash, believed to be connected to a crime. No one's going to argue that you want to give proceeds from drug sales back to a drug cartel to put into their operations. But the concern, Rena, is with people who perhaps are initially suspected to be part of a crime, lose their property, but are later found out to be completely innocent. And whatever the reason for that initial stop or initial search was, is found to be not connected to any sort of criminal activity. Those people have historically had a very difficult time getting their property back from the government, particularly if they don't have a lot of resources. It costs a lot of money to go up against the Justice Department. This is why almost half the states and the federal government have tried to limit this practice of asset forfeiture.
So what exactly is Attorney General Sessions doing here?
Right now, he is saying that if you are in a state, any state, but especially those that have required now, you can only seize assets if it's connected to a criminal charge or a criminal case. If you're in one of those states, now if you join up with the federal government, you can still practice asset forfeiture. So this practice is called adoption. It's a loophole for states where this is banned for local law enforcement to still seize assets. And then if they share the proceeds with the federal government, they get around their state restrictions. Now, this is enormously controversial because many people are concerned that this in some way gives state and federal government authorities the ability to seize private property without having to prove that it was connected to a crime.
And aren't most Republicans against this policy, Paula?
Yeah, Rena, I mean, there is broad bipartisan consensus that this practice needs to be reformed. It was limited under the Obama Justice Department. Eric Holder limited this practice of adoption. Today, Darrell Issa, he issued a statement. He called this new policy a troubling step backwards, even with the safeguards that are in place. And even Justice Clarence Thomas, in a recent Supreme Court opinion, he noted that this is a very troubling practice. He said it frequently targets the poor and other groups, those least able to defend their interests in the proceedings. So this is a pretty far out there position to reinstate asset forfeiture when half the states and the federal government have been going through the process of reform.
So you've got Issa and Clarence Thomas coming forward saying that this isn't something you should do. So why is Sessions doing this now?
A recent independent watchdog report within the Justice Department found that a lot of local police departments depend on the money that they got from seizing these assets. The independent watchdog report from the Office of Inspector General also noted that these kinds of programs, this adoption program, is very important for local and federal cooperation. Now, many law enforcement agencies believe it's an important tool for them to conduct criminal investigations. But again, it is extremely controversial, and over half the states have been pressing successfully to reform the practice.
Quickly, before you go, Paula, I got word that the U.S. Supreme Court is temporarily allowing the Trump administration to include grandparents in the travel ban and limited entry of refugees. How significant do you think this is?
This is a minor step. If you remember in the Supreme Court decision agreeing to take out the travel ban issue, they said that they can enforce the travel ban except when it comes to close relationships. Now, Rena, anyone knows that close relationship, that's a pretty vague term. So the administration came out with a list of people they considered to be close relations, and there was pushback on that. And even immediately after the list came out, there's already some sort of evolution. For example, fiancés were excluded, but within a few hours they were included. Well, grandparents were also excluded, but now the Supreme Court, after some litigation out in Hawaii, they have now said, yes, grandparents constitute a close relationship. But ultimately, Rena, the final word on the travel ban will come in the fall when the Supreme Court hears arguments about the policy as a whole.
All right, Paula Reid, thank you for joining us, Paula.